I'd like to jump into protection of the environment. And I mentioned what's happened in the Gulf. Stan, are Colorado laws to protect the environment and to protect our citizens from polluters adequate today? If so, tell me why. If not, tell me what we should do. And John, I want you to answer the same question.
Well, I think, and let me answer it again by reminding everybody of the role of the Attorney General, which is to enforce the laws that exist. I think the laws that exist on environmental issues in Colorado are largely good and adequate. And I can tell you that, one of the things that 22 years in private practice will give you is the opportunity to represent clients who are on the other side of those laws from time to time. And I learned a lot representing clients who'd been accused of violating environmental laws, and I have learned a lot enforcing laws on behalf of clients in that area. So I think the laws are adequate. I think it requires focused and effective enforcement that makes it a priority and that is responsive to the needs of the community.
I also think that the laws are adequate. What we have in Colorado is, let's face it, we have a great deal of natural resources that are economically of great benefit to the state of Colorado, but we have an immense natural beauty that we have to protect, and it's a balancing act. And we have to do the best job we can of taking advantage of the economic vitality that comes from the use of those natural resources, but also do everything we can to protect the environment. I told you about the three natural resource damage cases that we've resolved in the last couple of years. In the next month or so, we're going to announce the resolution of a case involving the city and county of Denver that's been going on for a long time. My folks in the environmental division are proactive. They're out trying to solve problems. That's the important thing. These litigations, the circle of litigations that Colorado filed in 1983 went on for over 25 years. An incredible amount of money was spent. If you can go in, pinpoint the issues, work with, in this case, the city and county of Denver and get those issues resolved, it's to the benefit of everybody, and get the pollution cleaned up. And that's been the approach that we've used. We have been incredibly active in criminal environmental enforcement. Talk to the EPA. The EPA spends more time in our office than they do in the United States Attorney's Office, simply because they think we're a lot more receptive to the types of what they're trying to accomplish in terms of environmental protection.
Can I ask a question, Aaron?
Please.
John, that's good to hear. Let me ask you a question. In, I think, 2006, one of the amicus proceedings that you engaged in was the Duke Energy case. And as I understood the Duke Energy case, the issue there was a North Carolina, a southeastern utility that was challenging the applicability of a amendment to the Clean Air Act. And you entered an appearance on behalf of them as an amicus in the United States Supreme Court. What is the connection between entering into that litigation, which again is part of a series of what I think is partisan litigation, where you're entering in as an amicus or otherwise, and maintaining a clean environment in Colorado? Wouldn't you think that most people would want the Colorado Attorney General, if he's going to go down to the southeast and get involved in litigation for some utility, to be on the side, like I believe something like 32 other attorney generals were, on the side of keeping the air clean?
Stan, you need to do your homework a little bit more. What other states were involved in that case? Kansas, Wyoming, both Democratic AGs, Nebraska, Colorado, all states here. The issue that we were concerned about, and something I suspect we'll be talking about, is we spend an awful lot of time in the Attorney General's office protecting federalism, preventing preemption of federal law over state law, allowing the states to regulate things that the state want to regulate. The 4 regional states, their problem in that case was that EPA had been wholly inconsistent and in some cases contradictory in their application of the quality standards. Interestingly enough, in the Supreme Court decision, our amicus was quoted by the court. The Supreme Court said, the charges that the agency has taken inconsistent positions and is now retroactively targeting 20 years of accepted practice have not been tackled by the district court or the Court of Appeals and should be raised on remand. And in fact, on the remand, that's been a big focus of the trial court. I make that was of significant interest to western states, which frankly are always concerned about EPA trying to preempt state regulation.